My subject is straightforward. What is objectivity and what does it demand in a legal system? Now, this is pitched to beginners. I, like Peter Schwartz at least, was told to make this more for beginners, people who are relatively new to objectivism. So veterans will find much of this familiar, though I do hope that some of the fresh angles or ways of putting, ways of putting things might deepen even people who are more familiar, deepen their understanding of some of these issues. Why should we care about this? Why should any of us, beginner, old-timer, why should we care about objectivity in the law? Well, we can't improve the legal system if we don't understand what to aim for, what's possible and what's proper. And I do mean understand, not simply assert. What would be an objective legal system? What would that consist of, at least in basic terms? This is also important because it's easy to fall into intrinsicism and dogmatic claims about certain legal policies. It's easy for people new to objectivism, but not only those who are new to objectivism, but people who are inclined favorably toward a lot of objectivism's views on government issues, to condemn certain particular government actions, an internet regulation, for instance, or a court ruling, to condemn them as self-evidently wrong. Well, they're not. They're not self-evidently wrong, even the ones that are wrong or unjustified. But we also need to understand how objectivity rules in a legal system to guard against subjectivism, liberty being a like, something you like, that sense of like. Objectivism stands in contrast with many libertarians who advocate for limited government, not because they understand its value and its moral grounding, but essentially because they want it. The animating attitude for at least a lot of people is, who's the government to tell me what to do? Who is anyone? I should write my own ticket. Objectivism understands the value of freedom, that its value does not rest fundamentally in its getting what you desire, but in freedom's making you able to acquire what you need via reason. It's all grounded in man's nature and his natural needs. Notice, objectivism is not alone in endorsing most of the political positions that we do. What I mean is, we have some allies on these issues and some allies on those issues, right? There are some people who agree with us about socialized medicine or environmental regulations. There are usually some other people who might agree with us on assisted suicide or abortion. I've even heard there's somebody who agrees with us on foreign policy. That's still a rumor, not yet confirmed, but there might be, I don't know, there might be somewhere. We're looking for him. See if he can donate, maybe. So, given that, look, we have some allies, different ones, cross-cutting groups on political issues, even some legal issues, what's our distinctive advantage when it comes to thinking about the law? Basically, I think, and again, very basically, two things. Morally, our understanding of a proper legal system as grounded in individual rights, unapologetically. We're able to be so unapologetic because we uniquely espouse egoism and a view of proper government as a means of applying that to that realm of organized social relations. So morally, we get that. We get the grounding of rights. Epistemologically, we know that objectivity is possible, that it is attainable, that there are answers to even the most contentious value questions or political disagreements. We know that certain things are essential, in fact, to life, to justice, to freedom, and correspondingly, that specific legal policies will be right or wrong, justified or not. Because I was asked to gear this to newcomers, I will indulge in a little recommendation, okay? For those of you who are relatively new and haven't worked through a lot of the things that you want to read in objectivism, you really ought to read the objectivist epistemology. That is the base of everything, of the objectivity of everything in objectivism. Now, it's a difficult book, right? Don't be deceived by its comparative brevity. It's a difficult book. I'm not saying you need to master it. I'm not saying everybody should approach it as if you were a philosophy major. But that account of objective concept formation matters for issues like this morning's, right? What's a proper, objectively valid legal system? Now, I don't mean to frighten you. I'm not going to, today, in talking about an objective legal system, get into the nitty-gritty of conceptual common denominators and the open-endedness of concepts or all of that. But I do want to say that Ayn Rand's explanation of the rudiments of epistemology there nails the pattern for objectivity in any sphere. She is there explaining the principles of being objective for you as a decision maker, for the government as a force wielder. Okay? Finally, in the preliminaries here, I have a book coming out in the fall on judicial review in an objective legal system. And much of what I'm talking about today is drawn from that. Not directly, not structured in the same way that a lot of these ideas appear in the book, but I mention it in part to say I go into a lot more detail, a lot fuller explanation of many of these issues there, okay? My outline today is very simple. First, I'll discuss objectivity at some length, and then objectivity in the law, okay? Also, I am going to use legal system and government interchangeably, strictly. There are some differences between them, but I don't think they matter for our purposes, so don't be thrown by that. I mean essentially the same thing by both as I talk about them today, okay? You know, I look at you as if I want some response. I couldn't see anything anyway, so I'll just, everybody's smiling and nodding and, ooh, yeah, okay, yeah. Y'all look good doing that, so keep it up. Oh, thank you. Oh, there you go. Ask and you shall receive. Thank you. So what is objectivity? Easier done than said. But most people have an intuitive sense. They feel like they know it when they see it, or especially when they see its absence. The lack of objectivity or the abuse of objectivity, right? They're ready to call out, oh, that's biased. Or that was a completely subjective decision that group made, right? People are often very ready. They feel confident in their grasp of objectivity in that sense, though if you ask them to define it, no doubt they would stumble. I'm sure a lot of us would stumble somewhat if looking for a definition. So to get at what objectivity is, we need to start by asking, what kind of thing is it? What's its genus? What's the general category of thing we're talking about here? We also need to ask, why seek it? What's its point? So on the first, what kind of thing is objectivity? It's a method of using your mind, a manner of thinking, to reach conclusions, to make decisions. If I'm trying to determine whether or not to believe in God, or whether to believe in global warming, or how much to spend on a car, or whether to hire Harry or marry Mary. Lots of things vie for my mind's assent, lots of observations I make, things I hear people say, arguments I read, and so on, right? Lots of things are in there vying for my mind's assent. Objectivity is a deliberate discipline of conducting one's thinking to assess those. Many of you know this well. Reality is not objective. It just is. If that rose is red, that rose is red. If echinacea won't cure the illness, echinacea won't cure the illness, right? It's people who can be objective or not objective in how they think about reality to reach various conclusions. So that's the general kind of thing it is. Method, manner of using your mind. My second question a moment ago was, but why should we seek to be objective? Why bother with a discipline, a deliberate manner of thinking? Essentially, to be right, to draw valid conclusions, to know things, and because only certain ways of thinking enable us to be right. Given certain other facts that I won't go into today, but given the primacy of existence, volition, our fallibility. Being objective in your thinking is not a guarantee of being right, of reaching accurate conclusions. It doesn't bypass our fallibility, but it is the means by which a man can know whereof he speaks. The point is, the object of objectivity is knowledge, getting reality right, so that we can make sound decisions, sensible judgments about actions. Okay, but still, what is objectivity, right? I've said something now about the kind of thing it is, about why we should seek it, what it is objectivity. For starters, a belief is objective when it is held for reasons, as opposed to being held baselessly, arbitrarily. But more, a belief is objective when it's held for good reasons, the right type, the type that are indicative of the truth on the specific issue in question. Much of what might be true on an issue isn't necessarily telling about the particular question that you're considering. For instance, who should coach the Little League team? There's some Little League team you're concerned with, right? Who should coach the Little League team? Well, the fact that Boaz is bright and sincere and passionate, might all be true of him, right, doesn't make him the best man for this role, right? The fact that the medicine tastes good to toddlers doesn't make it effective for whooping cough. So the objective thinker has to sort out reasons. Now, further to help us understand objectivity, consider an exemplar of objective thinking, the scientific method. What are its hallmarks? Well, the method is rooted in looking, or using whichever of the five senses, right, might be relevant in the given kind of thing you're studying, right? But looking, hearing, sensing, smelling, observe, that's what's key. Heed reality. And we all know the drill in various form of this, you know, even very non-scientific people like myself, right? I mean, if you just recall some of the basics of the scientific method, you form a hypothesis, you test it, you study a large, diverse sample of specimens, observe with care, precisely, thoroughly, vary the conditions of your trials or experiments. Repeat them to exclude distortions that might have been introduced by accident. Hold different variables constant in different trials to isolate the role of each of the possibly salient factors. Blind the results in certain ways to exclude other possible distortions. I mean, the point is, the scientific method is a systematic effort to understand the reality in question. Is this medicine effective, right? Will this material withhold that much weight under these atmospheric conditions? It's driven by the quest for accuracy, to identify the facts, to gain knowledge, to get reality right. The scientific method's signature features, I think, illuminate the essence of objectivity in all spheres. For it's actually an application of objectivity, and it helps us to appreciate that objectivity is, at its core, a reality-anchored and logic-guided method of reaching conclusions. To be objective is to be guided in the use of your mind fundamentally by reality, by the nature of the thing in question. The objective inquirer proceeds on the basis of what each factor is, as best as he can discern, rather than by what he might like to believe it is, or what certain others think it is, or what he has some other incentive to say that it is. In drawing inferences, his reasoning, the objective thinker, his reasoning is guided scrupulously by logic. And remember what logic is. The art of non-contradictory identification, identifying facts of reality, be they objects, physical objects, or properties, or relationships. And I do just want to note, when I speak of the object, the thing studied or thought about when you're engaging in an objective process, that does refer much more, it doesn't refer only to physical or material objects, right? It refers to any existent. Different kinds of existence, different facts of reality are relevant when I'm trying to decide objectively how much to spend on a car, how much time to devote to preparing this lecture, whether to leave a job, whether that person is trustworthy, okay? In whatever realm, the objective thinker strives to proceed solely by the relevant evidence and logical inference. Excuse me. Okay, what is the relevant evidence? The answer depends largely on one's purpose. In assessing job candidates, what's the job? Am I hiring a sales manager, a wedding planner, a therapist? What's the scope of the job? Okay, it's a sales manager. Is it going to be managing 4 people or 40 people or 400 people? What qualities do I think are the best indicators of success in that role? A friend recommends her therapist, telling me, he always makes me laugh. I mean, that's great, but obviously not exactly what you want. I hope that's not what you want in a therapist. Now, I do want to be careful here. The idea in bringing up purpose, the idea isn't that you can manipulate the demands of objectivity by fiddling with your purpose, but rather that the forthright identification of your purpose will steer you to the relevant facts of reality that objectivity demands that you attend. Now, in popular discourse, people think they understand objectivity. Again, I don't mean that they're confident that they could give you articulate definitions, but they know a raw deal when they see one, right? They know a biased opinion when they hear one. So people are, they're quite confident that they understand objectivity, and at the same time, they espouse a host of misconceptions of what it is, which are damaging because they pollute people's expectations of a truly objective process. They encourage us to settle for procedures that aren't truly objective. Now, in the book, I talk briefly about 4 or 5 of these different misconceptions, and I just don't have the time to go into them here. I talk about them briefly in the book, but maybe a couple of pages on each. But here, I will take a little time to address that just one of these misconceptions that's reflected in this toxic refrain that we frequently hear. Well, who's to say? Who's to say? I'm sure you've had the experience. When that is injected into a conversation, it's treated as a decisive veto, right? Unanswerable. End of conversation. End of reasoning about the issue. And notice a variation of this, a form of this that we heard about that we're all familiar with, but Elan Giorno in his lecture a few days ago was reminding us of. Who are we to tell the Palestinians a better way to govern? Who are we to say there are better ways? Who are we? Well, that's it, man. You want ideas in action? Yeah, that's it. More people are dying as a result of this idea, if we could even call it that. But notice, who's to say? Its unspoken premise is, as long as people disagree about an issue, no one can be right. No position can be correct. With anything less than unanimous agreement, claims of objectivity are a fraud. Problem. Objectivity is not a matter of who thinks something or of how many think something, whether a view enjoys consensus. This perspective of who's to say gains traction, I think, because it's true that no one is privileged in the sense of being endowed with a special inside track on knowledge. That much is true. No person's claim should be accepted just because it's he who says it, who makes the claim. But the conclusion drawn, that is, that no one can claim a truth unless everyone agrees to that, that conclusion doesn't follow. If, on some particular thesis, some people have relevant experience while others do not, and some people have relevant training while others do not, and some people have relevant skill and facility with the subject involved while others do not, and, what's most important, if some people adhere to the strictures of objectivity while others do not, then those people are in a position to declare a conclusion objectively valid. And we have abundantly more reason to attend to their conclusions than to alternatives not reached on similar grounds. The reason that we do is not those people's being an anointed, privileged caste that issues arbitrary professions of objectivity, but the validity of the evidence and the arguments that they provide for the conclusions they affirm. These people are still fallible. We shouldn't treat their word as gospel. But their claims are distinguished by their presentation of strong arguments. Arguments which remain open to refutation by anyone who can make better use of the objective method to offer still stronger arguments for different conclusions. So the answer to that cynical query, who's to say, is anyone who can prove his case. Expert or amateur, the test is in reality, not personality or the number of personalities who agreed to a certain thing, okay? And again, that's what objectivity teaches us. It's all about reality. And by the way, again, especially for those of you newer to objectivism, Ayn Rand has, the essay that taught me this about this issue. She has an excellent brief essay. The title is either Who is the Final Authority in Ethics or Who is the Final Authority on Ethics? But I'm pretty sure it's in the Voice of Reason collection. Excellent. I mean, again, sometimes when you say something's excellent, it sounds like, I knew that, and isn't that, getting this all from her. So, but great essay you should check out if you're ever troubled about that kind of issue. Okay, how are we doing? So now I'm getting to the second part, objective law. How does this apply to the law? Because a legal system isn't a conclusion like a belief in God, right? And it isn't a decision to hire this guy, to look for a different job, whatever issue you're deciding about. A legal system is a whole big apparatus of offices and agencies and staff and laws and forms and procedures and penalties. I mean, it's a big, complicated thing. How does objectivity apply here? Well, to get a handle on this, let's come back to 2 points that I made earlier, both concerning purpose. That the purpose of an activity helps us determine what objectivity demands in that particular realm, and that the overall purpose of being objective is getting reality right, as I put it, knowing the object in question, often so that you can then act appropriately toward it. So, reminding ourselves of those observations, in this realm with law, what's to get right here? Government's use of its coercive power. That's what government distinctively does. It enjoys a monopoly on the use of force. Law is a kind of gun control. A legal system is the way we order, along the appropriate lines, how guns, how force more broadly, may be used in society. So how then can a government, a legal system, get it right? What would its objective operation consist of? Essentially, using its power to serve its function, the reason for which it holds that power, which is the protection of individual rights. Using its power exclusively for that. That's the crux of legal objectivity. That's the fundamental distinguishing feature of an objective legal system, a proper legal system. Just as a hiring committee conducts its business objectively if it adheres strictly to relevant evidence, logically assessed, to reach its conclusions and make its decisions, so a legal system conducts its business objectively if it adheres strictly to evidence relevant to its mission, logically assessed, to reach its conclusions and make its decisions. In this case, to make laws and thereby exercise its coercive power. Function is pivotal. And excuse me, but I have a function is pivotal. When an agent, be it a single person, a single individual like you or me, or a group or an institution, which is what a government is, right? It's an institution. A college is an institution. The Ayn Rand Institute is an institution, right? When some agent has a specific purpose, reference to that purpose or function is immensely clarifying of the demands of objectivity, because the purpose establishes the basis for its proper mode of proceeding. Now, knowing your function or purpose, that doesn't part the sea. It doesn't dissolve all questions about proper policies, but it orients further thinking along the proper avenues, okay? I'm sorry, I just mixed my metaphors there, but all right. It orients you in the right direction. When it comes to government, the idea is you guys get to control the force, but only so that you protect everyone's rights. You get that monopoly on the use of force on the condition that you use it for this specific purpose. When you stick to that mission in exercising your power and adopt logical policies to fulfill that function, you are operating as you should. That is an objective legal system. Can we be a little more specific about how it's conforming to reality, since that is the linchpin of objectivity as I've portrayed it? Yes, let's try to be a little more specific. How is it adhering to reality? Through the rules that it enacts and its manner of enforcing those rules, the way that it applies them. When things go astray in either of those dimensions, first with what rules it enacts, right? We've got to consider such things to see if it's adhering to reality in the proper ways here, right? Does this government adopt its rules carelessly, hastily, with little reflection? Does it write its rules ambiguously, making them difficult to understand and difficult to obey? Does it erect rules that exceed its mandate? Right? That's all, those are just some of the questions under what rules is it enacting. But, so if things go wrong there, or if things go wrong here with its manner of implementing or applying its rules, right? Is it applying them erratically, giving favor to friends, by exempting some groups for non-relevant reasons, by punishing violators disproportionately to the gravity of the offense? Again, the thought is, when a legal system goes astray along either of these paths, it is no longer operating to advance the end for which it enjoys the coercive power that it does. It's not adhering to the relevant realities. So again, function. The purpose of having a legal system sets the compass for objectivity in the law, for the government's using its power for the right reasons, on the grounds that adhere logically to the nature of the realities in question. What are those realities? Let's see if we can get just a little bit even deeper here. What facts does a legal system need to get right to serve its mission? Many, many, many things. The more I have thought about it over time, sort of the more impressed I am by how many things a proper legal system needs to get right. Let me simply indicate three broad the broadest categories of reality that I think it needs to get right. The first is the simplest. It needs to understand the nature of rights, right? If its job is to protect individual rights, then the government, the legal system, needs to have a good idea of what it would look like for a legal system to be doing that, right? It's got to have a clear, accurate image of what successful rights protection would be. A society in which rights are protected. What would people's interactions be like? What would you not have in such a society? Government's got to understand that. Correspondingly, it's got to understand freedom, the type of freedom that your rights encompass. Freedom from what? From a wage that's less than I wish it were? From an overbearing boss? From a neighbor who helps himself to my swimming pool? From a hacker who, does whatever he does to gain access to the money in my bank accounts, right? So freedom from what? Freedom to what? The government has to understand these sorts of things to make rules that will, in fact, protect our rightful freedom. So that's one crucial, the most obvious, I think, thing that a government needs to get right in order to operate objectively. Second, it's got to understand certain basics of human psychology, of the way people normally think, of why people typically do the things they do, what affects decision-making. For its rules to be effective, such that most people will comply, and thereby further the end of our residing in a rights-respecting society, government has to know its audience, right? These rules we're making are for, oh, okay, people. How do people normally think and operate? So it's got to understand who the rules are for, kinds of information they're going to need such that they would abide by these rules. They need to understand something about motivation, the elements that affect people's decisions. For example, if it's got to devise punishments that will in fact punish and deter, but not be so harsh as to alienate people, right? Make people resentful and think this government is ridiculous if they're going to punish that minor an offense that harshly and so on, right? It's got to think about that kind of thing in devising the particulars and implementing its system, right? Think about something like police techniques. I mean, there are informed discussions and debates that the people setting policy for a given police force have to adopt. One issue is if a cop is entering a potentially violent situation or already violent situation, should he enter with his hands on his weapons or not? Which is more likely to trigger certain sorts of reactions in others that would escalate the violence or defuse the situation? I got to think about all this stuff. So I don't have a nifty formulation for this point, but the basic thought is simply that aspects of human psychology should influence decisions about the rules that are made and the way that they are implemented to have an optimally performing objective legal system. Okay? And then the third, still really broad category, but I think there's something here yet, if I still haven't really put my finger on it. A proper legal system has to understand human circumstances to some extent. Facts about the normal course of life, the kind of stuff that happens. Now, I went to the soundbite department, but it was right before OCON, and they were booked, so they couldn't come up with anything better than that. And I tried the lexicon, but stuff that happens, I don't know, Dr. Binswanger left it out. But it's a technical term for those of you who are new to objectivism. Stuff happens. Weird stuff happens. Exceptional circumstances do arise, right? You miss the filing deadline for your taxes or whatever it might be because there was a major power outage in your end of the city for like 2 days or something like that, okay? Yeah, I hit him because he hit me first. Weird things happen. Oh, that's not the weirdest thing. Weird things happen. People sometimes break rules, laws, by mistake, without intending to. Should the legal system care about that? Should that matter? What sorts of excuses should a legal system accept or recognize or treat differently, right? Should it distinguish among felonies and misdemeanors and so on? So the larger point, I hope, is apparent. There are a number of realities for a legal system to heed and get right. These merely skim the surface, but they indicate some of the broad areas of what it's got to be concerned with to do its job properly. Okay? Let me also say just a couple of words on this. I've spent a few minutes here talking about some of the implementation challenges for an objective legal system. We shouldn't underestimate the challenge of figuring out which laws to administer. What I mean is which laws to adopt in the first place. I think it's easy for us, and I know I have lapsed into this often, it's easy for us to sometimes assume that, well, once you know the function of government, protect individuals' rights, it's pretty easy to figure out what kinds of laws we should have. And while I think it's true that it's easy to figure out what kinds of laws we should have on that basis, right? When it gets to a lot of specifics, it's much, much more difficult. I mean, think about just intellectual property for a moment, right? Well, what should the terms of a copyright right be? How many years? You got to think, I mean, that takes careful thought, right? Patents, still an intellectual property, right? What degrees and types of inventiveness should warrant a patent and your right to that patent and so on? And again, there are a host, I'll skip a few here, but there are all sorts of hard questions about what the laws themselves should be that I know I, and I think others sometimes tend to bypass in thinking, oh, function is to protect rights, that's easy. Well, no, there's a lot more work for, specialized work for specialists in law philosophy, law implementation to be thinking about. Okay. And one of the, I think, clear upshots of much of what I've been saying is that an objective legal system is a demanding enterprise. Our thinking about it must begin, though, again, must begin by getting the fundamentals right, the function of government. That function sets the compass because it's the source of the legal system's authority, of its right to rule us, of its license to practice law, to make laws, and to enforce them, taking that word very literally. So let me condense what I've been explaining in a framework that I actually introduced in a lecture a couple of summers ago at OCON. That was the lecture, The Politics of Pretend. Same basic framework, I think, is helpful, that I spoke of there, is helpful for thinking about objectivity in the law. Basically, it turns on three factors: what the legal system does, how it does it, and why it does it. Why in this sense, in the sense of what is the authority by which it does what it does. So let me say just a little bit more about each of those. Sorry. When you have a mic on, turning away really doesn't do anything. I just learned that. So, what it does, how it does it, why, what's the authority by which it does it. A little bit on what. What are the content of its rules, of its laws, the restrictions that it imposes? They must be designed with a single purpose in mind: rights protection. A nation's laws tell people how the government power will be used, and they are how that power is used. They constitute its policy on using force. Thus, for a government to govern as it should, the content of its laws is crucial. A nation's laws must restrict exactly those things, and only those things, that are necessary in order for the legal system to fulfill its function. When the content of laws is misguided, the government is not doing its job. It is not serving its purpose. The how of a legal system, its basic manner of administration, that's also crucial. You might have laws whose content is perfect, impeccable, irreproachable, right? But if those laws are interpreted subjectively or applied erratically, the value of that valid content is completely sabotaged. It does the individual to whom the law is applied no good. And it means that the government is straying from its legitimate purpose, that it's using force to favor friends, for instance, or to favor political causes that some in office prefer, as we saw with the IRS a few years ago, the targeting of certain nonprofit groups. Or it could mean simply, not by nefarious intent or anything, but it could mean simply that the government is bungling the due process safeguards in its investigation of crimes or what have you. So the point is, the implementation is really crucial to get the benefit of laws that are even well made, well constructed, okay? And then finally, the third, the why dimension. We cannot know which rules to adopt without understanding the authority behind the rules. The what depends on why. The way to determine whether specific legal prescriptions are valid is by reference to their underlying rationale in relation to the system's authorizing mission. By what warrant should the legal system govern these things and not those? Why should it protect a person's freedom to travel but not to trespass? Freedom of religion but not to rape? Or should it? Well, we can't know what the legal rules should be unless we know why they should be. That is, what authorizes the legal systems having any such restrictive powers at all. I mean, in fact, even more strictly, we can say that both the what and the how, the content and the administration of a legal system, both of those stem from the system's what for, its reason for being. We can't know the standards by which to evaluate either apart from understanding the authorizing mission of the system as a whole. So again, in essence, legal objectivity depends on the legal system's what, when, and how. Okay. It still seems rude to cough in your face somehow. I don't know. I'm sorry. Thank you. I don't think so. I think I'll thank you, though, thank you. Okay. Okay. Now, what I'd like, we've basically covered objectivity in a legal system. What I'd like to do now is apply this understanding of objective law to a particular region within the legal system. How does this apply to judicial review? I don't have the time to go into this in any depth. I'm just going to sketch. This is something I do go into in depth across 3 lengthy chapters in the book. But here, just try to indicate a little bit of how I think objectivity does apply to the issue, the question of judicial review. And quick refresher, if you're thinking, oh, judicial review, what's that? Judicial review. The court's practice of considering appeals to particular uses of legal power. I mean, you can put this in very different ways. That's not, the canonical definition. But that's what judicial review is, right? It's courts considering appeals that people make when they complain, whoa, the government did this, be it this local official, this federal official, whoever, whatever office, they did this. They're not allowed to do that. That's against the law. That's against the Constitution. So judicial review is the power of a court to judge the constitutionality of the actions of various of the pieces of the legal system, okay? And to orient us in thinking now about how does objectivity apply here, what's the function of judicial review? To ensure that it's the law that governs, without any of its agencies exceeding their authority, acting beyond their legal mandate. If, this is one way I think of it that I find helpful, if the police police the people, the courts police the law, ensuring that it has the last word in how the government's power is used. Cases up for judicial review, the appeals that go to court and are considered, they concern competing interpretations of what a given specific law means and allows. Courts are asked to determine things like, does this police action constitute a search, such that it would require a warrant, right? Does this requirement violate those people's religious freedom? Would this legal requirement violate the Equal Protection Clause? These are the sorts of things that come up in judicial review. Courts are to ensure the rule of law. Now, how to do this? In the book, I talk at length about it. I elaborate on 2 basic guideposts. One, objective judicial review requires respect for context and hierarchy. I haven't talked about those this morning. I do talk about them in the book. But basically, because a legal system is an integrated system, rather than a scrapbook of isolated edicts, the interpretation of the legal system, of the law, must be holistic. Courts must honor the fact that our law is philosophically informed, animated by a commitment to certain abiding principles. It must understand that those principles and the overall purpose of a legal system constrain the rational reading of any of its discrete elements. Respect for hierarchy here requires recognition that the Constitution has greater authority than statutes, for instance. That the Constitution sets boundaries around what legislatures, be they state or federal legislatures, may do. This is a fact that is often neglected by our courts. And 2, the second guidepost, the object here, the object of judicial review, is the law, which may seem obvious until you realize all the extraneous factors that courts are continually urged to place before that. The array of different schools of thought on judicial review, how judges should apply the law. Really, when you study those, what you come to realize is that it's basically, the array of them is basically a roster of so many ways of deviating from the law. To wit, and this is just going to be a quick trot through a few of them, okay? Courts are told to abide by precedent, previous court decisions. Although what previous courts have said about the law is not the same thing as the law. Right? The history of a legal system isn't the law. Or courts are told by many to be minimalist, Steer small. Don't do too much, courts. This mode, minimalism, is, some of you have heard me talk about it before, very fashionable these days across the ideological spectrum, everybody from Cass Sunstein to Samuel Alito and to John Roberts, Mr. John Roberts. Anyway, I told myself this morning, but you have to be professional. You can't, okay. But the Q&A maybe. Q&A. The minimalists, right? But again, this is the sort of dominant, the most fashionable mode these days. Minimize the judicial footprint. Size of you know what matters about your decisions, courts? Size of impact. Courts should rule narrowly in ways that won't be too disruptive, which is a complete diversion from what the law says, right? If the effect of a court ruling upholding the rational meaning of some constitutional provision would be drastic, well, so be it. That's the law. But minimalism has better fish to fry, right? They've got higher gods to serve. They would elevate various political considerations above the law. But let's consider a few more of these different schools of thought on how judges should do their work. Living constitutionalism, another mode of judicial review. Make America better, courts. Yeah, we have principles, just like Tara was saying a few minutes ago. Ours is an aspirational society. So courts should help us realize our ideals in light of enlightened opinion today. Or consider popular constitutionalism. Courts should defer to what the people want. We're a democracy, after all. Majority will. Let the states or polls determine what the law is. The problem with both of these two, living constitutionalism, popular constitutionalism, what people think we should be, you know, their ideals, their aspirations for the best just society, even if they're right about that, about what we should be, or what a majority would like us to be, neither of these is what our laws now are, and that's what courts are to uphold, right? Democracy is not law. A lot of people don't seem to get that. They don't seem to get that law is a distinct concept, a distinct phenomenon. Democracy is one way of making law, of choosing certain laws, but it's not the same thing as law. Here again, contrary to the way a lot of our Supreme Court justices frequently treat the law, right? They'll often argue, we, the court, should defer to the democratic branches, allowing democratic will to trump the law. The fundamental law of the land is the Constitution, and the majority doesn't get to change that by weekly poll. If it did, then we would be making the rules up as we went along, and that's not the rule of law, right? Still just a few more. Nor should courts proceed on the basis of the wisdom of foreign law, as a certain contingent has been telling us in recent years. This actually got a little more attention a couple of years ago. It's quieted down somewhat. But, you know, the argument many will make is, you know, the French don't treat their criminals that way. The Canadians do this other thing this other way, or, you know, this is the policy that seems to be working in South Africa, or the UN Convention on God knows what. You know, they say this and this. So, and increasingly, this is coming into the reasoning of justices in the appellate courts. Now, what's obviously true here is somebody's got a good argument or just, you know, reasonable argument that bears addressing. Who cares where it comes from, if it's foreign or domestic, right? Sure, arguments should be listened to, whatever their nation of origin, but foreign practices are not our Constitution, and that's what our judges swear to uphold. And finally, even originalism, which I think is beloved to many objectivists, and people are attracted to because it seems the best game in town, and it makes a lot of good criticisms of many of these other schools of thought. Even originalism, folks, I say that for any of you who don't, some of you I think already are with me on this, originalists offer only new flavors of intrinsicism and subjectivism. Just quickly, the Scalia version, textualism. Text divorced from context is not objective law. The text of our law doesn't contain legal answers that are revealed to the sincere spectator. The words of the Fourth Amendment by themselves don't answer our questions about a police's installation of a GPS device in a car and whether or not that's a search, et cetera, okay? The words of the First Amendment by themselves don't tell us whether a license plate is government speech and whether Texas should allow Confederate flags on its license plates or what have you. Legal language expresses concepts that require abstract thought for their logical interpretation. It's not a game, reading, being faithful to the Constitution isn't a game of paint by number or Simon Says or something as mechanical as that, okay? And even another school of originalism, which many consider much more sophisticated, public understanding originalism, or the original public understanding originalism, is ultimately no better. Because instead of searching for the objective meaning of laws, this kind of originalist tells us to treat some earlier people's beliefs about meaning as sacred. What those people who made the law thought these words meant is what we all must take them to have meant. Those guys might have been right, they might have been wrong, but we've got to obey them. The written law and its objective meaning, no. We are bound instead by some men's beliefs about meaning, whatever those happen to be. Essentially because they got here first. Now, I will say, there's a lot more to be said on all of these, in particular on these last, these couple of versions of originalism, which I've just said a couple of things about. I do go into them in great depth in the book. And I will say, I especially recommend my critique of originalism, because that's pretty intricate. I actually make very direct use of objectivist epistemology in talking about that. And I think it's important that we not get suckered into originalism. But here, again, just want to underscore a basic point. An objective legal system demands that courts in judicial review go by the law and deflect the numerous factors that people press on it that would actually tear us away from the rule of law. Okay. So, to wrap up this segment, let me reiterate. Objectivity in general is a method of thinking that's deliberately anchored in reality, disciplined by logic, for the purpose of getting it right, of knowing the object in question, to equip oneself for sensible decisions and sensible action. Correspondingly, an objective legal system makes its decisions about what laws to adopt and how to administer them based on the reality of its authorizing function and all other aspects of reality that must be attended in order for it to fulfill that function. So a few words in conclusion. Objectivity isn't easy. The more complex the enterprise, the more abstract the goal, the more difficult it is. The more the more factors you have to sort out, the greater the number of relationships between those factors you have to consider, right? I mean, if your goal is catch the mouse, there seems to be a mouse in the house, catch the mouse, right? It's pretty easy to go about that objectively, to figure out the sorts of things that one might need to do to have a good objective procedure to trying to catch the mouse. If my goal is protect individual rights, for 320 million people while you're at it, right? Not just for you and your wife and kids or something. You're going to have to Google that one, right? I mean, that's a little more complicated. We won't be able to achieve a rights-respecting society, to have a proper government, a proper legal system, unless we understand what it stands on, what it is and what it stands on. What happens without objective law? Guns are loosed from their holsters. I mean, that's metaphorical in a certain sense, but the truth is, yeah, what it means without objective law is force is used where it shouldn't be. By government to restrict you in ways it has no authority to, in ways that violate your freedom. By private individuals who the government allows to encroach on what is yours. Individuals who it helps to pick your pockets by shelling out a wage against your will, forcing you to subsidize the doctor visits of strangers, right? I mean, what happens when we don't have objective law is your freedom shrinks. And thus the capacity of your mind, what your rational thinking is able to do for you, that shrinks, that's just blunted. Which means that your life, your finite lifetime, is not what it could have been, is not what it should have been. An objective legal system is an impressive accomplishment. I'll tell you, from working on law in the last few years, I have tremendously more understanding and respect for what a good legal system is and all that goes into it than I ever had. It's a tremendously valuable accomplishment as well. Because for a legal system to be objective means that it is effectively protecting our rights, safeguarding the platform that's indispensable to your ability to lead a flourishing life. The objective rule of law is worth fighting for. And I think we can have it. I think we can get more of it back. So I hope you'll go out there and try to understand it and fight for it. Okay, thank you. Thank you. And I'm glad we have a lot of questions. We might even be able to get to some live stream questions, so. Yes, sir. Ed.
It's a wonderful, wonderful talk. Thank you so much.
Thank you.
I have a question that's related to what you said. Are there, other than in antitrust, where it's very obvious.
I'm sorry, other than
antitrust, where it's very obvious, do you see a lot of problems in improper definitions of legal principles? In antitrust, it's ridiculous. We know that. Are there other areas where you see that as a problem?
Okay, that's an interesting question. Yes. I think there are many areas where law is very ambiguously stated, increasingly, deliberately, which is really offensive, to put it mildly. But think about, I'm thinking about harassment law, sexual harassment law, not only sexual harassment, but, some of this arises with speech issues, what is offensive, what should not be allowed in various, in an office place or on a college campus and so on. The actual laws that come down often from executive agencies like the EEOC, the Equal Employment Opportunity Commission, they implement a lot of equal protection law in certain domains. Their language is often incredibly either ambiguous or such that there's no safe way to proceed, such that you can confidently say, okay, I'm obeying the law here, right? They're written in deliberately. A lot of securities regulations are written in very ambiguous terms. A lot of that is related to antitrust. I feel like I'm forgetting some right now. Let me think a minute. The vagueness is sort of across the board. It might be more concentrated in certain areas than in others, but I do, in one or two of the chapters, I give a number of examples of just badly written laws, and when you read about them, you will often read about how some of these are deliberately ambiguous so that we can catch these guys, or we have a bigger net with which to catch these guys, which obviously reveals a wonderful attitude. Talk about understanding the purpose of government. It's like, how can we catch these guys? And it's not only the fat cats on Wall Street that they want to catch. Damn, I'm not thinking of them. I'm sorry?
RICO, somebody mentioned RICO.
RICO, I'm just sort of blanking, but there are a number of areas where the law is, yeah.
Thank you.
Yeah. Is there someone over there? No, yeah, hi.
Hi. So your talk was making me progressively mad. You alluded to our currently favorite Supreme Court Justice Roberts. And I guess my question is, when a law gets interpreted by the courts, especially the Supreme Court, by disregarding the explicit text of the law, or by deciding that the words really meant something totally different, then how in the world can an objectivist person respect that ruling?
Well, I do think we need to be very careful. Something I said quickly is very important. Interpreting the law is conceptual. It's written. It's important that it be written. You can't ignore what the words say. But to understand conceptual communication, which is what the law is, which is what, any single provision even of our Constitution is, it's conceptual. It's not, I said it's not Simon Says, it's not paint by number. So we have to be very careful that we do not erroneously think that the words say this, by themselves, those words therefore obviously mean this. Language is contextual. Objective meaning is contextual. So I want to caution against proceeding as if the meaning of concepts is always self-evident. It isn't, okay? Now, that's not to defend Roberts or various misrulings, I think, okay? But anyway, so on the one hand, caution against oversimplifying or thinking that legitimate, logical, objective interpretation is a simpler enterprise than it is. It isn't. But to sort of more the heart of your question, I guess, whichever particular decision or reasoning by an individual justice we might get under our skin the most, how can you still respect the system or respect the court? It's increasingly difficult to. That is, the more often we see justices deviating from what their sworn oath is. I mean, they are to uphold the law. We have become so accustomed in this country, though, to that's not being considered the primary responsibility of anyone in the legal system. And it is not that only the courts are to respect the Constitution. All three branches, when they are sworn into office, legislators, executive, they're all sworn to uphold the Constitution. And something I'll talk about tomorrow, there's an optional talk that I'm giving on constitutionalism. I think I talk about it a little bit in there. Actually, maybe I don't. At any rate, all three branches are to uphold the Constitution, right? The law, the fundamental law of the land. But increasingly, they don't. They go by what the people want, or they punt it, the courts will figure that out as if it's just their job. Well, it's not just their job, it's my job too. I shouldn't sign a presidential signing statement saying, I don't think this is constitutional. This is what a presidential signing statement is, right? Many of you know this. They'll sign it into law. Something's been passed by the Congress, and a president, Bush had many of these, Obama has many of these, they all have some of these. I don't really think this is constitutional, they'll say, but I'll sign it anyway. What the hell? I mean, that's a defiance of their oath of office. How can you respect that, right? I mean, Congress people do this, presidents do this. The courts will sort it out. It's their job. And then everybody tells the courts, we're a democracy, so you shouldn't do, who are you to say what the law is, what the law means? Leave that to the other branches. So and again, a lot of times the people put pressure here as well. We've gotten so far from the idea of the law is what is supposed to govern. Change the law if you don't like the law. We can amend our Constitution, but we don't have the courage of the Constitution. We have courts who don't have the courage of the Constitution's convictions, people who don't have the courage of our convictions there's this defect with our Constitution. If you really think that, then amend the Constitution. So it's hard to respect so many of the players who get away from, well, if we really want the rule of law, then we've really got to enforce the rule of law, and we as people have to endorse the rule of law rather than the rule of, what we might like.
And what good is changing the law, though, if, I'm real specific, the first ruling about calling a penalty a tax, that's not my understanding of the words, and then the second ruling of stating, well, it wasn't really meant that it only applied to to exchanges set up by the state. It really meant the whole federal government, even though that Goober guy made it quite clear that they knew what they were doing. Mm-hmm. So I guess I'm frustrated because because now we have the highest court in the land. I don't mind having the legislative branch make the laws, but now the Supreme Court is deciding what
I mean,
what the words
sometimes,
meant.
no, I mean, I certainly agree with you that, I mean, there are cases and opinions in which I think are given, this reasoning is ridiculous, is absurd, is deliberately manipulating what the law is, which is why, and, it's sad to say this, but it's why I don't have respect for many of the individuals on the courts who I wish I could respect, right? And who we'd like to be able to respect so that we could feel some confidence that they were really trying their best to give, to properly understand and apply the law so that we could have objective law. So how can we, I don't know. I mean, how can you respect somebody, if you think somebody's dishonest, it pains me, I think some of the, I think a lot of people, well, I don't know. You can't respect them, but you can make reasoned arguments for what's wrong with some of the arguments that they give and really try to show and press on people what we should be going by. I mean, there's a lot of thinking that has to go into proper judicial review.
Thank you.
Thank you for your talk. So, epistemological chaos versus ideological conviction, for example, Justice Roberts and the conservatives. If you had, say, let's say the Institute of Justice, which likes to argue things on the basis of individual rights, and you presented a case based on, a good argument based on individual rights, would that have influenced Justice Roberts, for example? He would be forced to follow that logic rather than, say, going towards collectivism. It seems to be chaos. So if you presented a good argument based on individual rights, would that kind of guide him in his thinking, or would he just...
No, right? I mean, I think on the premise here, right, this guy proceeds in a very chaotic way. So do you think he'd go for this kind of argument? To the extent that you truly think somebody's thinking method is chaotic, who the hell knows, right? It's unpredictable, truly. A few things to keep in mind. All you can do is the best you can do, right? And you put the arguments out there as groups such as the Institute for Justice and many, rational, soundly oriented legal practitioners do, whatever their firm and so on. I mean, you put the best arguments out there. Some people, including some people on the courts, will hear them, will respond to them, respond rationally to them. There's also the fact that what may not win in a given case on a given day can have influence down the road. This is part of why dissenting opinions are important. It's part of why, today we've got such a mishmash of sometimes good decisions given for bad reasoning and bad decisions with some good but convoluted, it gets very complicated looking for where there are some better arguments about the law and the proper understanding of the law. But you couldn't confidently expect, but if I make this kind of argument, that's going to work. Once a mind throws reason aside, all bets are off, okay? But what you can do and what you should do, whether you're a litigator, whether you're just a person thinking and talking about these issues, is you try to understand the fundamentals and explain exactly why you think this interpretation of the text is wrong, or this wouldn't apply here, and so on. And some people will hear and will be honest, and some of those people are people who matter in the, who have positions of influence in the law. And I will say, and some of you have heard me say this kind of thing before, since I turned to legal philosophy 8 or 9 years ago now, I've found the legal community honestly responsive to argument. And I've seen signs of people of influence in the legal system. The people at the good law schools who go on and become clerks at different levels of the judiciary and do a lot of reading and for their justices and reasoning with their fellow clerks, and some of these things having an impact on the reasoning that you'll then see in the highest court, the various high court decisions. So I do think, and that's part of what, It's part of why I said at the end, I really do think we can do some very important, good work and make some good progress in this legal arena. That's been, I'm not prone to over-optimism on that sort of thing, but I really think we can. I'm sorry I can't give you cheerful answers. This is turning into a sort of downer. I don't know. Maybe we need that talent show now. Yeah. Yeah. Yes.
Can you comment on the idea or the common refrain that you can't legislate morality? And in an objective system, how often is it appropriate, or to what extent, to invoke morality in, say, judicial review or otherwise?
That's a very interesting question about legislate. You can't legislate morality. Let me say a couple of things, 2 or 3 things. The role of government is not to make people moral. In that sense, it is importantly true that you should not, a proper government, an objective legal system, should not try to legislate, this is what it is moral for a human being to do, this, therefore, we will have laws forcing you to do these things, penalizing you if you do not. The function of government is to protect individual rights. It is not to enforce everything that it is right for a given individual to do or not do, okay? But rights themselves are a subset of morality. I mean, that's the way I think of it. They are not amoral, A-M-O-R-A-L, right? They fall within the sphere of morality. However, rights pertain only to freedom of action. To say that you have a right to something is to say you should be free to do it, to control that issue, that decision for yourself. You have authority there. It does not approve of or condemn how you are. I mean, simply to say that you have the right to do that, in saying that, I am neither approving of nor condemning the particular ways you exercise your right. Now, not the government, but a private individual should go ahead and think about, what do I think of the morality of the way this guy is exercising his freedom, right? But that's not the government's business. That's the end of morality. That's not. So government is not to legislate morality, but it is to protect our rights, and we have to understand that rights themselves are a moral concept that emerge out of a proper understanding of egoism. Yeah. If we could talk more about that, if you like, afterwards, okay? Because it's a good question, and so feel free to come up afterwards if you want to talk more.
Hi, Tara. You mentioned different schools of thought.
Could you maybe put the mic down a little bit, I think? Thank you.
You mentioned different school of thoughts in interpreting the Constitution. So my question is, when you establish a school of thought where objectivist epistemology is used to interpret the Constitution in the right way, what would you call it?
Objective interpretation. I
you.
mean, that's what I think, that's what I'm going for. What is the objective meaning of the law? And it's not easy. I mean, it's complicated on some of these issues. What is the objectively proper understanding of certain things? It can get a little complicated, but yeah. And again, I stress the difference. I have some articles on originalism that talk about how original isn't the same concept as objective, and we need to understand the differences. And anyway.
Yes, hello. I actually have 2 questions. First one's very easy. You referred to the book, and I'm not sure what the title of the book is that you wrote.
Thank you.
And the second one is an important question to ask at any point in the logical chain of the validity of a law or a review. What is the essential definition? I mean, for example, you gave 2 great definitions of, minimalist judicial review. Well, that's actually a non-essential, whether it's minimalist or not, and whether it's popular. Again, that's a non-essential. It seems if there could be an agreement or at least an assertion regarding what an essential is along the way, meaning to protect rights would be an essential, is that perhaps maybe the most important question to ask in the logical chain of the validity of a law?
The question, what is an essential?
Yes, in other words, should that question be the one at the forefront in other words, if we're not describing something by an essential, are we then simply just creating a rationalism argument?
Okay. I think so in thinking about these different schools of thought, minimalism, popular constitutionalism, what have you, what they all do is get away from the function of government and the function of law, the function of the Constitution, right? Which is to say, this is going to be bedrock law in this country. Everything else, and it's a hell of a lot of stuff that all the different tiers and layers and different agencies and branches of our government and legal system have to do. It's whatever it does, it's got to be consonant with this. This is the fundamental law of the land. And again, with all of these different schools, minimalism, textualism, popular concept, et cetera, there are all so many ways of getting away from the law as the paramount thing. Bringing in, and a lot of them, they won't say, oh, we shouldn't go, they won't typically say, we shouldn't go by the law. We should go by something, oh yeah, the law, and what the people want, and what would make us better as a society, and not being too disruptive, just minimizing and so on. So I'm not sure that putting it that way of what's the it's not usually a bad idea to ask about the essentials, right? But I do think function is one concept that I've found very helpful in my thinking, to often come back to function. But the function of what? The function, what's the function of the government? What's the function of judicial review? To uphold the law, to make sure it's the law that governs, right? So it can be helpful to get people to think about, well, why do we have judicial review? What are they supposed to be doing, right? Now, but you're not going to get people to quickly agree, oh, yeah, they should just be doing that. You've got to clear a way, but aren't we a democracy? Or they weren't elected. There are all sorts of arguments that lead people off track, but they weren't elected. Those are just 9 men, or okay, maybe there are a few women now. It's like, who are they to say? Well, they are only saying what the law says. And again, if you don't like what the law says, if you don't like what the Constitution says, change the Constitution, right? But they're sworn to that same Constitution that all of the others are, okay? I suspect that there might be more to what you're saying about the essential than I'm fully getting here, so I don't mean to be overly dismissive of that, and here again we might want to talk about that a little bit later. But let me not pass up the opportunity to advertise my book. Thank you. So yes, my book is coming out in the fall. I'm very excited, very happy. And it is called Judicial Review in an Objective Legal System. It's supposed to come. It'll probably come out in October. They've mentioned different months to me, but it'll probably come out in October. I'm sorry to say it's going to be expensive. It's one of those academic books, and right now the price they have up, they've only given it in British pounds, but it's like 68 pounds. And hopefully in about a year it'll come out in paperback, but I don't mean to discourage you from buying it. But anyway, it's interesting. Thanks. Thanks. How are we doing on time? Good.
Hi. The couple living next door to us are a living contradiction because they are both lawyers and decent people. So we've been in. That was a joke, of course.
But yours got a laugh.
Sorry?
But yours got a laugh. I make
okay.
these jokes and they're like.
Okay. Just quickly. Of course we get into discussions with them, and we bring up, sometimes we bring up the obvious, like, we don't think you have a right to other people's money. And then, the lawyer kicks in. Oh, of course it's right, because that's what the law says. At least in Germany, and then, but you see, and you give him the obvious objectivist, leading him to, well, that's not moral, it's not right. And then he goes down the track, but you can't, morality, that's not what it says in the law. And then if you ask him, but do you really think that's right? And he says, what's right is what it says in the law. And then you go down that track, and the next time the same discussion comes up again, and you start all over again. And it's like we haven't been able to pierce that sort of lawyer screen that he seems to have, and we have been very unsuccessful of shaking him out of that. I mean,
Yeah.
I'm basically asking you for a devastating quip that will shake him out of there or whatever, and there's no such thing. But
See, now this
that
is
must
when the
have come
gun
up
should
with your
come out.
students, I think.
I'm sorry?
That must have come up with your students, I think.
Yeah.
So how would you go
Yeah.
about?
I mean, it's interesting because it relates to one of the earlier questions in a way. But let me say in defense of my lawyer friends, thank you, duly noted. Many lawyers don't think that way, and many other people do think that way. That is, this is what the approved law says, end of story, right? Well, as in answer to one of the earlier questions about legislating morality, one of the observations I made was that, look, rights are a moral concept. Yeah. And some of the thinking there is that, yes, we should have laws, but we should have a system of proper laws, proper, morally proper, insofar as they are designed to do one thing and one thing only, protect our rights. But it's that whole idea that a moral system has to be informed by certain moral conclusions. Now, I mean, I do address that in the book. I have a chapter on that. There is no simple way, but it's to say that, I mean, part of what's relevant here that, you might talk about a little bit in having conversations with people is the sheer fact that a lot of people think that something is so doesn't make it so. The sheer fact that most people want something. Let's say these were democratically supported laws in Germany or wherever it might be, right? But can't the people be wrong sometimes? Not only wrong about the most scientifically, factually true or false issues, but even in what they want. Since government is using guns, right? Government forces people to do certain things. So if if more people want me to spend my life this way than I want to spend it, it's okay for them to force me to do this. I mean, so you can break it down into smaller sort of chunks that sometimes people find more digestible. I remember an example that Yaron Brook has given in some talks a few years ago, more than others. He would just talk about, and I forget the exact example, but he would talk about how if a bunch of neighbors decide, no, we want your money for the sick kid that one of us has or whatever it might be, that doesn't entitle us to it. And the sheer fact that we passed it by a big Democratic majority, it doesn't give us the right. So there's a morality underneath the law, but good luck. Thanks. Maybe we have time for one more, I think, if I'm quick, and I think so. We don't? I'm sorry? Oh, thank you. Okay.
I'm curious what your thoughts are on the regulatory state as it functions to objectivity of law, especially that we have these administrative agencies that can issue hundreds, if not thousands, of rules with seemingly little or no oversight.
That's an area about which I don't know much. But it seems to be the case, from what I know, that the delegation powers that the Constitution allows for have been abused by the executive branch. And again, this is not just speaking of one administration. This has been going on for decades. And the legislative branch as well, in sort of delegating the implementation of certain legislation to agencies and giving them much more authority than they should properly have, courts treating them with deference that is completely not just exaggerated but also ill-founded, such that the regulatory agencies have acquired a tremendous amount of power. People like to talk about the unaccountability of those unelected judges on the court. Well, similarly, the lack of accountability for a lot of the regulatory agencies is ridiculous. But I don't know enough to say much more, especially quickly, coherently on that. Sorry. But it's not a good trend for objective law at all. I mean, in so many ways, yeah.
Yeah, this is the live stream question.
Yay, live stream. Glad you're here.
Could you comment on the attack on free speech with the use of so-called Islamophobia?
Oh boy. Only very, I mean, we did, unfortunately, and I'm sorry to have to say this to you out there in live stream land, we had a whole panel on free speech the other day. Is, in a certain sense, be it, the silencing of speech based on or related to Islamophobia, I mean, the broader category is offensive speech, or speech that some people find offensive or hateful, and there are slightly different terms you could use for it. And the offensiveness of speech per se, be it to my Islamic sympathies or my objectivist sympathies or whatever my sympathies might be, right? The fact that someone or some group is saying something that I find offensive, deeply and sincerely, or hurtful to me personally, or hateful of me, is irrelevant to their right to say it. I mean, what free speech means and protects is you can say whatever you like as long as you're not infringing on my rights. Call me the vilest names in the book. You're not infringing on my freedom of action to lead my life however I like. So, I'm sorry, there's so much more to say about those speech issues, but that's why you have to come in person next year. Live streamer. Okay, thank you.